Hi, Herman.
Good morning, Judge. How are you?
Hey, man.
Mr. Payne, if you want to read along when the prosecutor does, you can read right there. It says, Vicente Payne, Your Honor, page 11 per Victoria.
Thank you. Good morning, Mr. Payne.
What happens when a 21-year-old gets behind the wheel after downing 4 tall boys, causes a 3 CAR pileup, and then blows nearly 3 times the legal limit? You're about to find out. This is a case of Vicente Payne, a young man whose night out turned into a courtroom nightmare that could cost him a year behind bars and $4,000. But here's where it gets wild. When his lawyer tries to negotiate driving privileges, this judge delivers one of the most savage responses we've ever seen on this channel. We're talking open containers, failed sobriety tests, and a judge who makes it crystal clear that she will protect her city at all costs. Buckle up, because this arraignment is about to get intense. Let's break it down.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Okay, let's pause right here because this is crucial information. The judge just said elevated to a Class A misdemeanor because of the high blow. What does that mean? In Texas, a standard DWI is typically a Class B misdemeanor, but when your blood alcohol content is 0.15 or higher, that's nearly twice the legal limit of 0.08. It automatically bumps up to a Class A. That means more jail time, bigger fines, and a permanent stain on your record. And spoiler alert, this guy blew a 0.23. That's almost 3 times the legal limit. The prosecution isn't playing around here, folks. Now watch what happens next.
On March 15th at approximately 11:22 p.m., the officers were dispatched to a 911 call regarding a 3-way motor vehicle crash at the intersection of Spencer Highway and 11th Street in Harris County, Texas. The defendant's motor vehicle was identified by his Texas license plate. The officer made contact with the defendant and observed slurred speech, red glassy eyes, a strong odor of alcoholic beverage, and poor balance. During the investigation, it was apparent that the defendant's motor vehicle failed to yield the right of way for left turn, causing the defendant's vehicle to strike Unit 2, causing Unit 2 to strike Unit 3. All parties involved advised at the time of the collision the defendant was operating his motor vehicle.
Did you catch that? He didn't just cause one accident. He caused a chain reaction. His car hit another vehicle so hard that that car slammed into a third vehicle. We're talking about innocent people just driving home on a Saturday night, and suddenly they're caught up in this chaos because someone decided 4 beers wasn't enough to stop him from getting behind the wheel. And the officers noted slurred speech, red glassy eyes, strong alcohol odor, and poor balance. That's not just tipsy, folks. That's visibly intoxicated. But wait until you hear what they found in his car. This is where it gets even worse.
The defendant advised that he consumed 3 tall boy Michelob Ultras at a residence prior to operating the motor vehicle. One open container was found cold to the touch and was located on the right outside of the defendant's motor vehicle's driver's side door, and that the defendant was advised that was his 4th beer. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 7 out of 8 on the walk-in turn, and a 3 out of 4 on the one-leg stand. The defendant was placed into custody and was transported to the police station. The DIC was read and sentenced to breath, which the results were a .234 and a .230.
All right, let me break down these sobriety test results because they're damning. 6 out of 6 on the HGN. That's the horizontal gaze nystagmus test, where they watch your eyes follow a light. A perfect fail score. 7 out of 8 on the walk-in turn. 3 out of 4 on the one-leg stand. And then the breathalyzer, a 0.234 and a 0.230. For reference, the legal limit is 0.08. He blew almost 3 times that amount. At that level, most people experience severe motor impairment, memory blackouts, and loss of consciousness. The fact that he was even able to stand is remarkable. And remember, they found a cold open container right outside his driver's door. Cold, as in recently consumed. Let that sink in for a moment.
Are you telling me that he had alcohol in the car and he's
Yes, Your
drinking
Honor.
while he's driving as well?
I cannot tell you whether he was drinking while he was driving, but alcohol was found in the vehicle.
Where was it?
It was found in the vehicle, on the driver's side door.
Mr. Payne, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what's going on in your life. If I find that you drive, I can have a contempt hearing. You could be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, Your Honor.
Now here's where it gets interesting, and I want to know what you think. The judge just issued a complete driving ban. Not restricted hours, not with a breathalyzer device, 0 driving, period. And she's threatening contempt charges with additional jail time if he violates it. Some people might say that's harsh for a first offense. Others would argue that when you cause a 3-car accident while blowing nearly triple the legal limit with an open container in your car, you've proven you can't be trusted behind the wheel. What do you think? Is this judge being too strict, or is she absolutely right to take this stance? Drop your thoughts in the comments below, but watch what his lawyer tries to do next.
Judge, may I request, I understand why the court is concerned about this case. Can we just limit it so he can just drive for the certain hours of the day so he can support himself to do the necessary things in his home with the interlock device and or scram device as well? I mean, it's hard, as you know, in Houston, Texas, it's hard for someone to be able to live where we have without any public transportation or anything to get around. If we can just limit his driving just to the specific hours that the court allows.
How old are you, sir?
21.
He's 21. He has beer in the car and he's a .26.
Oh, did you see the judge's face when she heard he was only 21? Let me remind you, the legal drinking age in Texas is 21. So not only is he barely legal to drink, but he's already caused a major accident while nearly 3 times over the limit with an open container in his vehicle. The lawyer is trying to argue about Houston's lack of public transportation, and honestly, he's not wrong about that. Houston is notoriously difficult without a car, but the judge clearly isn't having it. She just pointed out the cold, hard facts. 21 years old, beer in the car, 0.23 BAC. And her response? Watch this, because she does not hold back.
2-3, I thought, but I mean, I'm not to quibble, but yes.
No, you are not
Because the
to
bond conditions just
drive.
seem a bit egregious considering it's first off.
I understand, Herman, and I would recognize, or I would understand that it's elementary that you're not to have alcohol in the car while you're driving. And there's a 3-car collision. He's a .23 with alcohol in the car. No, I don't want you driving. And I'm telling you now, if I find that you do, there's going to be HE double hockey sticks to pay. Do you understand? You're also not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will be spending quite some time with me.
Will you reconsider the order or the condition, Judge?
I will always do it. Yes. I want some time to pass
Sure.
and I want to see some proactivity, Herman, and I'm always all ears. But for the moment, I don't want him anywhere near a car.
HE double hockey sticks to pay. You've got to love a judge who keeps it clean but makes her point crystal clear. But notice what she said at the end there. She's willing to reconsider if he shows proactivity. That's actually pretty fair. She's essentially saying, prove to me you're taking this seriously, attend your programs, stay clean, and maybe we can revisit this conversation. But right now, after what happened, she's not budging. And honestly, can you blame her? 3 innocent drivers had their nights ruined, their cars damaged, potentially their bodies injured, all because of a decision that never should have been made. Now watch the finale.
Is his appearance waived as long as he's maintaining his conditions, Judge?
Because you have a lawyer, I will waive your appearance. So you don't have to waste your time coming to court. But Mr. Payne, I want you to understand that I'm going to do everything in my power to protect my city at all costs. If that means putting you in custody, I don't care. If you have Jesus here arguing on your behalf, I will protect my city at all costs. Do you understand? So, all right, I'll have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria Center Reset. You'll get with Felicia for your bond conditions, then you're free to go.
And that, ladies and gentlemen, is how you laid down the law. Let's recap what we just witnessed. Vicente Payne, a 21-year-old, was charged with Class A misdemeanor DWI after causing a 3-vehicle chain reaction accident on March 15th. Officers found him exhibiting classic signs of intoxication: slurred speech, red glassy eyes, poor balance, and discovered a cold open container right by his driver's door. He admitted to consuming 4 tall boy beers before driving. His field sobriety test showed severe impairment across the board, and his breathalyzer results came back at 0.234 and 0.230, nearly 3 times the legal limit of 0.08. The judge found probable cause to proceed and imposed strict bond conditions: absolutely no driving, no alcohol consumption, no illegal drugs, and random testing. His attorney's request for limited driving privileges was firmly denied. The judge made her position absolutely clear. She will protect her city at all costs, even if Jesus himself were arguing the case. This is a powerful reminder that DWI charges carry serious consequences, and the courts are not playing around when it comes to public safety. If you found this breakdown as intense as we did, smash that like button right now. Drop your thoughts in the comments. We want to hear your opinion on this case. And if you haven't already, hit that subscribe button and turn on notifications so you never miss another jaw-dropping courtroom breakdown. Share this video with someone who needs to see it. Until next time, stay safe out there. And remember, the choices you make behind the wheel affect everyone on the road. Peace.